Hello, everyone, and welcome to Uncivil Law. For today's story, we are responding to an article. This is an article that was written in The Atlantic, that was written by a law professor, and it's entitled, What If the Court Saw Other Rights as Generously as Gun Rights? An interesting question. I consider myself a pro gun person, consider myself a supporter of the Second Amendment, so I thought we'd read this and see what it has to say. So let's get started with this. This is an essay about two words no one wants to see in the same story: guns and schools. Well, it depends what we're talking about and the context of it. The gun rights advocates would talk a little bit about guns in schools for two reasons. First of all, they talk about the need to have someone with a gun present to help defend the school. And they'd also talk about the need for gun education in schools. Justice Scalia is somewhat famous for, at the time when he was a high school student in New York City, he used to take his rifle with him, a 22 caliber rifle, I presume, on the subway to go to school because he had a shooting club at his school and they trained him on how to use firearms and stuff like that. So the idea of a student taking a rifle to a school in New York City via the metro today is a little bit foreign as a concept. But, there used to be pretty healthy school shooting clubs. There used to be pretty healthy um, shooting sports. And this definitely still exists in colleges to a lesser degree, but seems to almost have disappeared completely out of primary and secondary schools for some reason. So the gun rights advocates would talk about guns in schools in the sense of having defense and also in the sense of helping people be trained and familiar with firearms, which even people who are opposed to firearms normally say, well, we need more training. So, allowing people to be trained in schools when they're being trained for other things seems like a good thing, and it can be very fun. And personally, I find it to be very zen and very sort of just calming, very meditative, because shooting requires a lot of concentration. And so I find it to be very, very zen and very meditative. So there's that best benefit too. So that might be an aspect where people talk about in schools. This article is instead about two starkly different social activist groups: gun rights proponents and educational equity advocates. It's about their steadfast pursuit of wildly divergent civil rights. I don't know how wildly divergent they are. They're both civil rights, and they both go to the individual. So I'm not sure how wildly divergent they are, but it's about surprising similarity in their legal strategies. And more than anything, it's about a story about law and ideology and the difficulty of deciding the former without influence of the latter. So I'm certainly not going to pretend that ideology doesn't have any influence on the interpretation of law. In terms of trying to analyze them in a more holistic way, we try to look to more guiding principles. So conservative legal advocates will argue things like, as a general proposition, the legislature should govern. As a general proposition, the courts should take a secondary seat. As a general proposition, the will of the legislature, whether it's respected in the law or the Constitution, should govern, and Constitution beats statutes, and so forth and so on. So it's an issue of judicial restraint and looking to different tiers of legislation in terms of which should govern which. So that is a judicial philosophy that can help solve these problems. Both groups have long courted the Supreme Court's intervention. Certainly true. Spearheaded by new leadership at the NRA in the late 1970s, the revolt at Cincinnati, they call it. I keep forgetting what year that was, 1976 or 1974 that was, when basically, for all intents and purposes, there was a coup within the NRA. And the NRA, as you now know it / love it, was essentially created. Really interesting period where the self-defense advocates really took over the NRA. Before that was more of like a gentleman's kind of club, more like a country club thing, and they didn't really oppose restrictions, didn't really impose things. And then the more self-defense minded, the more prepper minded people took over the NRA. It's been like that ever since. Really interesting period of time. The gun rights activists engaged for decades in an effort to pursue the Supreme Court to recognize individual Second Amendment right to keep and bear self-defense arms for the home. They sure did. The court ultimately enshrined that right 12 years ago in D.C. versus Heller, displacing a long-standing consensus to the contrary. I think that's reasonable to say there's a long-standing consensus to the contrary. The long-standing consensus to the contrary had been in the circuit law. It had interpreted U.S. v. Miller, which I think itself was kind of a disaster of a case, which really shouldn't be relied on anything. But The consensus was essentially that the right of the Second Amendment was a collective right, didn't belong to any individual, and as a result, the government could regulate any way they want. So yes, it upended the interpretation, but I think correctly. In the years after Heller, however, conservatives such as Justice Clarence Thomas frequently complained the court had ignored this fledgling right by refusing to expand its reach beyond the facts of Heller itself, effectively resigning it to second-class status. And that has been a criticism from the gun rights people in general, is that the court has not taken enough of these cases. They tried to take one this term in New York State Pistol Rifle Association, but of course, the state of New York tried to moot it, and so they have trouble getting the cases. But the Supreme Court typically takes 1, 2, 3 First Amendment cases every year. So they could try to up the Second Amendment case law, not for at least the reasons that there's quite a lot of First Amendment case law on the books at this point, and so maybe the Second Amendment needs a little bit more attention from the court to help develop it and flush it out a little bit more. If we never had a Supreme Court First Amendment case ever again, we've got basically 90 years, give or take, of precedent on the books that we can work from. So it'd be nice to have something similar in the Second Amendment jurisprudence. Second class no more. In New York State Rifle and Pistol Association, a major case argued in December, the court appears poised to expand the Second Amendment to protect gun ownership outside the home as well. Well, that was true when this article was written, or at least when it was drafted. But it's not really true anymore because New York kind of mooted the law. So unless the Supreme Court does something really unexpected, they are not going to do anything right now. So that's kind of annoying, but it is what it is. Just how far is an open question. Though gun rights groups have focused for now on enshrining a right to transport guns to shooting range and second homes. Fair enough. You want to do this in a piecemeal approach. You don't want to, go right to the end of the page. You want to do it one step at a time. So you want to establish a right to bear arms of some variety before you go into what the full scope. So you want to enshrine a right to keep and bear arms before you really go to the most extreme elements of it. So I think that's a very fair summary from that. For educational equity advocates, the court's involvement has not been as helpful. The court declared in 1973 the Constitution guarantees no right to an education. Well, that's roughly true because any right is someone else's obligation. Your right is my obligation. And the Constitution as a general proposition doesn't have any positive rights. It doesn't say that there's nothing. A positive right is when the government has to give something to you. A negative right is when they can't take something away. So the rights of the Constitution are negative rights. Freedom of speech is not something government gives to you, but rather something they can't take away. Freedom of religion isn't something the government gives to you, but rather something that they can't take away. So the government doesn't have to help you and facilitate you. They don't have to give you any aid under the First Amendment, but they can't prevent you from doing stuff. So it's negative rights. So to the extent the Constitution did protect education, it would be a negative right to education. So because the Bill of Rights protects negative rights. So it would be the government can't prevent someone from receiving an education, but it wouldn't be that they would have to provide one. And that makes sense if you look at how the constitutional structure is given. So that works perfectly well. That ruling paved way for today's radically unequal public school spending patterns that reinforce and exacerbate existing socioeconomic and racial inequalities. Well, that's a very fair point, and whether or not schools should be funded the way they are is an issue of law that should be done. If the government is going to do something, then they have to do it on a relatively equal basis. So the government may not have an obligation to do it at all, but if they do it, then equal protection would seem to apply. So the government could presumably legally say there are no schools anymore, but if they're going to have schools, they have to provide them on an equal protection basis. So that is a fair complaint there. Like the gun activists, educational equality proponents have not given up their version of a constitutional solution. Equity advocates' present litigation strategy is exemplified by a case known as Gary B. versus Whittemer, which is currently pending in the United States Court of Appeals for Sixth Circuit. The complaint in the case is painful to read. Many classes in Detroit public schools are taught by unqualified substitutes, and many classrooms use textbooks that are decades old, or lack them altogether. School buildings are in complete disrepair. The temperature has risen to 110 degrees in one building because of the lack of air conditioning. Well, that is really, truly disturbing, yes. And students have to wear jackets and hats inside a number of schools during the winter months because of the lack of heat. It's a little less disturbing because you can always put on layers of clothing. but you can only take off so many. So the 110 is a little bit more concerning, at least to me. These schools, the plaintiff argues, have deprived Detroit school children of their basic right to literacy. Again, he uses that term basic right to literacy. Your right is my obligation. So if you have a right to literacy, that means I have an obligation to provide you literacy. Now, again, I may not be able to deprive you of literacy, but to say that I have to affirmatively provide it is not something you normally see in the constitutional context. A district judge rejected the plaintiff's theory in 2018, but a panel of judges on the Sixth Circuit Court of Appeals seemed more receptive during oral argument in October. And regardless of outcome of the case in the Sixth Circuit, the Supreme Court will likely have a final say, perhaps early as 2021. So I'm by no means an expert on educational law or the funding thereof. As a general proposition, most public schools, primary, secondary schools, so K through 12, are funded based on localities. They're based on school districts, which don't necessarily follow city lines. They're usually different lines. There's usually multiple school districts, especially in big cities. And so normally it's the people who pay taxes in that district that fund the schools in that district, which sounds fair on the one level, but of course there's some districts that are much wealthier than others because the tax base is much higher. So that does mean that, citizens in the same state, even in the same city, might be getting dramatically different funding, if not dramatically different educational results. And so that is a bit of a problem. And this is the way schools have been largely funded, in school, and since, they came up with the concept. Whether or not that should be the way things done, whether or not that complies with equal protection, I think there are some valid arguments to be had there. But, that is a reasonable line. Whether or not the way that these are being construed is fair and equitable under the 14th Amendment. At first glance, the gun rights movement and the pursuit of educational equity start with the gun activist position in New York State Pistol Rifle Association. One of their primary objectives is to vindicate a constitutional right to transport the firearms to any shooting range of their choosing. New York City at the time forbade certain gun owners with premises licenses from bringing their guns to shooting ranges outside city limits. At least that is before the city and state both amended the law to permit such travel because they panicked. The gun-owning plaintiffs wanted to shoot at ranges in New Jersey. The argument for a constitutional right to train at any shooting range is far from obvious. The Second Amendment speaks of the right to keep and bear, but says nothing about the right to train or practice. But it does say something about a well-regulated militia, and the word regulated in this sentence has been much debated. But it does seem to be that regulated means well-functioning or in regular time. So if you ever see like old pendulum clocks, sometimes they'll be printed with the word regulated. And what that means is that they're on a very even temperament. They're very synchronized, because otherwise it wouldn't be a very good clock. So one of the things that you need is the militia to be regulated, that is orderly and functioning. And one of the things that might make it orderly and functioning is a familiarity with firearms, which again would suggest that perhaps we should have shooting ranges because people are not using them as much for hunting purposes, for example, as the time the Second Amendment was invented. So you can read it into the text in terms of the well-regulated part. We want to have it well-regulated, that is well-functioning in regular order. And one of the things that we need is people being familiar with firearms, so we need to have shooting ranges. So you can make a pretty textualist argument for the ability to use shooting ranges. And just on a more practical level, it's like, don't we want people to be familiar with firearms? Don't we want people to have more safety and more training? So it's like, why would we deprive them of that? It doesn't really seem in keeping with our concerns about firearms issues. And we're a couple steps from martial law, but it's within the vein of possibility at this point. But ex parte Milligan basically says that you can only have martial law in those places in the country in which you do not have a functioning court system. Which, thank God for technology being what it is. The courts will probably have to bend a little bit in allowing more telework and telepleading than they ever wanted. But the idea that the courts can function is a lot more prevalent than it ever was. So I think, there were quite a few steps from martial law because the ability of the courts to operate does seem implied in the technology that's available. So we may be okay yet, but we're a couple steps from there, but it is something to be concerned about. So what do the gun activists argue? It's worth reproducing this argument from their brief verbatim, which emphasis adds a single word. The right to possess firearms for protection implicit, A corresponding right to acquire and maintain proficiency in their use. After all, the core right to keep and bear arms for self-defense wouldn't mean very much without training and practice that make it effective. And fair enough, you would make a similar kind of First Amendment argument too. Like the right of freedom of speech implies the right to buy magazines, implies the right to buy radios, to listen to broadcasts, implies the right to buy internet access to stream Facebook. So you can do the same kind of thing in the First Amendment analysis too. The idea of this implied thing to exercise it, right? So that's there too. The Second Amendment may say nothing about the right to practice at a shooting range of one's choosing. Well, I don't know that you necessarily have the right to do it at one of your own choosing, but you would have to right to presumably do it at one that is like reasonably convenient. So there is that, in other words. But that right ought to be recognized implicitly because it's important for an express constitutional right to have full meaning. But in the same way that like you wouldn't necessarily say, well, you can just have one that's convenient, you would do the same thing in the First Amendment analysis, right? So if the government wanted to like say you must buy from newsstand, these particular newsstands, you would make the same kind of argument in the First Amendment, right? It's like, well, I still have the right to buy it, but if the newsstand is nowhere convenient to me, you've infringed the First Amendment right by making it so inconvenient. So like, it would be the same functionally as saying, well, the First Amendment doesn't say you have a right to shop at any newsstand of your choice. It's like, yeah, and the government probably can, to some extent, say you can only buy from designated newsstands. But if the ability to get those designated newsstands is so hard that it infringes the right, then you make the same kind of argument in the First Amendment context. So this kind of argument is not a Second Amendment specific problem. Now consider the argument advanced by advocates of the constitutional right to basic literacy. Again, this is going to be interesting because I assume this is going to be a facilitation argument for the First Amendment. Let's see. Like gun activists and the right to functional training, educational equity advocates recognize the Constitution says nothing explicit about education, which it doesn't. But surely a guarantee of basic literacy skills must be implicit in the document in order to express rights to have meaning. I don't know that necessarily flows from the analysis, right? Again, this is negative liberty versus positive liberty. So again, the correlation here would be the government imposing or preventing you from having gun ranges. That's the issue. So the Second Amendment advocates are not arguing the government has to provide us gun ranges, a positive right. They're not arguing the positive right case. They're arguing the negative right case. They're arguing the government can't take away our shooting ranges. They can't put in place restrictions that put access to shooting ranges we want. No one in the New York State Pistol Rifle Association case is saying the government must provide us shooting ranges. But they are saying in New York State Pistol Rifle Association and in Chicago and in San Francisco and in LA that the government can't impose regulations that prevent private entities from establishing gun ranges for these reasons. It's a negative liberty. So what they're saying is not provide us gun ranges. They're not even saying government provide us gun competency. They're not saying provide us gun literacy. They're not saying government, you must teach us how to use firearms. Government, you must provide us these things. No, they're just simply saying government, get out of the way. So it's a negative liberty argument versus a positive liberty argument. It's a government, stop interfering with us versus government, you must provide something to us. And the Constitution does typically protect negative rights, not positive rights. The government doesn't have to provide you speech, but they can't interfere with your speech. The government doesn't have to provide you religion, but they can't interfere with your religion. The government doesn't have to provide you protest, but they can't interfere with your protest. And in the Second Amendment context, it's exactly the same. The government doesn't have to provide you a firearm, but they can't interfere with your right to get one. They don't have to provide you ammo, but they can't interfere with the ability to get ammo. They don't have to provide you shooting ranges, but they can't interfere with getting shooting ranges. So it's a negative liberty argument versus a positive liberty argument. So this author here is conflating negative liberty and positive liberty. He's conflating the negative liberty argument of the NYSRPA case, which is all about government stop interfering with our ability to do stuff. And he's saying, well, in these right to education cases, we have a right to education, but that's a positive liberty interest. So it's a completely different argument because it's not government stop taking away from us, but government provide us. And those are completely different arguments, at least to my mind. As the Gary B. complaint puts it, without access to basic literacy skills, citizens cannot engage in knowledgeable and informed voting, cannot exercise their right to engage in political speech under the First Amendment, and cannot enjoy their constitutionally protected access to a judicial system, including retention. Well, here, again, I'd have to respectfully disagree with you. The idea that people are literate is a relatively modern idea. It's even more modern than the creation of the Constitution. I don't know how many people are literate at the time of the founding of the Constitution, but I'm sure it wasn't as many as there are today. And the ability to engage in speech doesn't necessarily imply the ability to read. It certainly helps quite a lot, but you can speak and listen without the ability to read. And the Constitution, if it implies the right to literacy, then it always imply the right to literacy, right? The conservative does not interpret the Constitution differently today than they did in 1790. So they say, well, if you have a right to literacy today, you had a right to literacy in 1790, which doesn't seem implied by the text in any way. Now, the government can't prevent you from reading. They may not be able to prevent you from reading. They may not be able to prevent someone from teaching you how to read. But the idea that they have to teach you, the idea that they have to provide you speech, the idea they have to provide you liberty, again, is a positive liberty argument and conflicts with the typical negative liberty arguments that we typically make in the constitutional context. The identical logical structure that underpins these otherwise distinctive arguments presents a puzzle for the Supreme Court. How can a good faith accept the theory of implied constitutional rights for gun owners only to reject the same argument for school children? It's super, super easy. Super easy, barely an inconvenience. Here's how you do it. Negative liberty versus positive liberty. Negative liberty, positive liberty. Negative liberty. The government can't interfere with your First Amendment rights. They can't prevent you from learning how to read. They can't prevent you from engaging in speech. They can't prevent you from buying books. They can't prevent you from listening to things. And they can't prohibit you from going to gun ranges and stuff. But the government does not need to provide you gun ranges. They don't need to provide you firearms. They don't need to provide you ammunition. And they don't need to provide you liberty. It's a negative liberty versus positive liberty argument. How can the Supreme Court say one and not the other? It's really super easy. Second Amendment, negative liberty. Right to education, positive liberty. Totally different theoretical constructs, super, super easy. Barely an inconvenience. You guys like what I just did there? You guys like that one? You guys like how I law-splained to a professor of law? You guys like that, where I law-splained to a professor of law? How can in good faith accept one theory and not the other? Well, here's how you do it. You can do it without blinking an eye. You guys like that? I law-splained it. How can they do that? Here's how. I can do it without breaking a sweat. No problem. No problem. That was fun. That was more fun than I thought it would be. You gotta love it when I law-splain to a law professor. Well, law professor, let me explain this to you. Hey, Licky Glock. We were just talking about firearms. So, you missed out on a great discussion. Yet the consensus among close followers is the most likely outcome. Gun rights activists believe the court is primed to deliver them a victory in NYSRPA, while education equity advocates recognize the court's conservative majority is unlikely to rule in their favor. Yes, they are. Yes, they are unlikely because they require completely different legal theories, completely different legal foundations. They are not the same argument. If the government was trying to prevent people from being literate by denying them books, by banning education, by preventing people from teaching them how to read, then yes, you'd be in the same ballpark. But you're not in the same ballpark. You're asking a government to provide you stuff. It's not at all the same thing. Should it come to pass, a pro-gun, anti-school child result would reveal some bleak lessons about the Supreme Court and the influence of political ideology on the justices. Or, in the alternative, would reveal the concept of positive liberty and negative liberty and the differences therein. When logic cannot support divergent decisions, and yes it can because I've been explaining it for a little bit now, the public is left with the impression the court is engaged in just politics by another name. The Supreme Court is not a court and justices are not judges. Negative liberty, positive liberty. It's really not hard. This has happened before. The Rehnquist court famously took a cramped view of Congress's power to regulate violence against women and, ironically enough, gun possession in school zones under the Commerce Clause. Yes, they did, because we take a dim view of the regulation of things under the guise of commerce. So yes, we said that this was not regulation of commerce. Whatever else it might be, regulation of commerce, no. But when faced with a similar attack against Congress's power to criminalize homegrown marijuana protection and use, the court did a sudden about face broadly defending congressional authority. I actually agree with you on this one. I don't think it was consistent with the principles in the Reich case to really do that. Although it is more regulation of commerce than violence against women, which is not commerce, right? No one thinks that violence against women is commerce. It's decidedly not. Gun possession is a little bit more so, but yeah, no. The way it was written was to deal with gun violence, and gun violence is not commerce either. Um, so it was consistent with Wickard v. Filburn, what they did in the Reich case. But go see my earlier video on tree law that we did, and yeah, I'm obviously very, very critical of Wickard v. Filburn in the first place, and I'm critical of Reich for the same reasons. Perhaps then a neutral theory of implied rights, one founded on first principles instead of politics, ought to shape constitutional law. Okay, well, the ones that you're implying are still the question. And again, the Constitution speaks to negative rights. The Constitution doesn't require the government to really give you anything. It only prohibits them from taking stuff away. That's the point of the Constitution. Under such a theory, starting with shared values seems fitting, like negative liberty being a shared value, for example. To that end, consider Chief Justice John Marshall's famous declaration 2 centuries ago: "We must never forget that it's a constitution we're expounding. A constitution's very nature," Chief Justice Marshall explained, "requires only its great outlines should be marked, its important objects designated, and minor ingredients which compose those objects be deduced from the nature of objects themselves." Our Constitution is pretty broad in its construction. It is more principle and philosophy oriented than substantive, although of course it has a lot of substantive too, but it's relatively short. So it is more about that. And again, when you look at negative liberty versus positive liberty, we want to prevent the government from interference with stuff. Like the right to vote in particular, the right to education is preservative of other basic and civil and political rights. Yes, but only to the extent the government is trying to prevent you from being educated. If they're trying to prevent you from being educated, then you have a First Amendment complaint. If they're not giving you a First Amendment education, you don't have a First Amendment complaint. Now, you might have an equal protection complaint because they're not providing it evenly, but the idea that you have a right to education, a positive right to education, is not borne out by the Constitutional. If one agrees with Heller's individual self-determination interpretation of the Second Amendment right, which incidentally is also a negative right, you have a right to keep a firearm in the home. Heller doesn't say the government has to provide you a firearm, or a home for that matter, so it's a negative right. An assumption that, to be sure, is subject to powerful counter-arguments, then individual right to train with firearms would be entitled to the same logical underpinning. Yes, it is as a negative liberty interest. The government trying to stop you from getting trained is imposing on you. So it's a negative liberty interest because the government's trying to stop you from doing something. No one's arguing the government has to give you a firearms education. No. A lot of people are arguing the government should by, having it more in schools, but no one is arguing that they have to. That's not consistent with NYS RPA or the Second Amendment case in general, no. So that is the end of this article, What If Courts Saw Other Rights as Generously as Gun Rights, by Aaron Tang, professor of law at University of California, Davis. Well, Mr. Davis thinks that there's no way for the Supreme Court to rule against the right to an education and simultaneously rule for the right to firearms. And I say yes, there is, because one's negative and one's positive. And so it's pretty easy conceptually to separate it. But it was worth our time to go through this article and to highlight why what he thinks applies from one to the other doesn't apply from one to the other. And that's our end of this coverage. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.